your boxes for your business? Or what if you invented a machine that actually folded the boxes for you? These are some things that would potentially be subject to patent protection. So in the US, if you think that you have something that is subject to patent protection, you're going to want to do what's called a prior art search. And there are a couple of platforms that you can use on your own to see if there's anything else out there that is similar to what you think you've invented. You can use Google Patents. That's actually a pretty decent platform to seeing what else is already out there. And then you can also use the USPTO website, and I have it listed right there. And just to let you know, it is a little bit clunky in terms of searching, but it is a good starting point. And of course, you can just use the internet these days as well to see what else is already out there. Um, at the end of the day, before you actually go through the process of filing a patent application, you're probably going to want to outsource any type of searching to a third party. Probably a search firm or even a law firm can do a search for you and then give you an analysis of those results and kind of give you an idea of whether or not your invention could be patentable. Patents are quite expensive to obtain, and it's a fairly lengthy process. Okay, let's go to the next slide. Let's go to the fun stuff, Jesse. This talking about trademarks. Your subscription box business definitely owns at least one trademark, even if you don't really know it, and that would be the name of your subscription box business. So think about the company's Birchbox. The name Birchbox is a trademark, and also Kiwi Crate. So what is a trademark? A trademark is a word, a name, a symbol, or a device, even a sound, which is used in trade with the goods to indicate the source of the goods and to distinguish them from others. So the cool thing about trademarks is that not only is it something that adds value to your company, but trademark law also exists to protect consumers. So let's go to the next slide, Jesse. And let's talk a little bit about recognizing trademarks. So like I mentioned earlier, a wide spectrum of words and combination of words or symbols can be used and protected as trademarks. Like I said, these trademarks can actually extend to colors, sounds, the MGM lion's roar that you hear at the beginning of MGM movies, that's actually a protected trademark. And shapes and textures. And I've shown a few pretty famous trademarks down here. On the left, you'll see the blue box. I'm sure a lot of you recognize what that is. That's the Tiffany blue box. Tiffany and Company owns the trademark Tiffany and Company. Obviously, they own a ton of trademarks, and probably one of their coolest trademarks is that robin's egg blue. That is a trademark owned by Tiffany Company, and they're the only jewelry company that is able to use that very distinctive, very iconic color. The Apple logo, we all know what that is when we see it. And then, of course, being from Kentucky, I have to give the Maker's Mark bourbon as an example of an awesome trademark. Of course, we see the mark Maker's Mark here, which is a trademark, but there's also another trademark here, and it's the red wax. And so the reason I'm giving this to you as an example is I really want you to think outside the box when it comes to what you might have as part of your business that could be subject to trademark protection. And so when people look at that red wax, they should immediately think about Maker's Mark. And that kind of goes back to just what I mentioned, that trademarks act as source indicators. If you're driving down the road and you come to a red light and you look at the car next to you and you don't see anything on it except the wheels, and you notice that there's a little blue and white kind of flag on it, your brain is going to immediately think that's a BMW. That car originated from BMW. So those are just a few examples. So in the U.S., we recognize what's called the spectrum of distinctiveness, and it's a sliding scale of predictability, where the more unique and distinct a term is, the easier it is for the owner to claim and be granted exclusive trademark rights for that term. And trademarks all fall somewhere along this scale of distinctiveness, ranging from coined, which is the strongest, down to generic, which is pretty much worthless. So I'll go into a little bit of detail about each of these and give some examples for you. So coined trademarks are very strong trademarks. They are typically totally invented, made up words. And a lot of times you'll see words are sort of squished together. You'll see, um, two separate words or, elements are taken out to make one word. Those are coined words. And I've given some examples here. Kodak, Bulu Box, I believe that is if I recall correctly, I think that has to do with fitness and health. And then there's Prosperly, which is one of Jesse's boxes. And the word Prosperly is a coined word. As far as I know, it doesn't, there's the word prosper. Jesse, do you want to give us maybe a little bit of, I don't want to catch you off guard here, but could you maybe tell us how you came up with the name Prosperly for your box?
Yeah, sure. I can do that. So the idea behind the name was when I was first coming up with the idea, I kind of wanted to include, everything that you need for like a happy, prosperous life you'd get each month. And so I
Uh-huh.
kind of landed on that word prosper or prosperity. And I
Uh-huh.
wanted to make it different because, uh, number one, because prosperly.com with spelled with an E was not available. So I had to make it different so I could actually get my
It's
custom
okay.
domain.
Okay.
But I kind of said to myself, oh, I'll use a U because it's kind of like there's kind of a trend now with like startups where they will take a very common word and then just drop their own letter into it. And
Yeah.
it's an easy way to get a custom domain with that name. So that's how I kind of landed on it. I knew the kind of the nugget, the niche that I wanted to go towards, and then I wanted to find an easily identifiable name that also kind of took people by surprise. I wanted them to see it and be like, "Is that Prosperly? Like, how do I even say that? Like, what is this? What am I looking at?" And so it was like I thought it'd be a good way to kind of intrigue people at the same time.
I love that. I love that. And I'm really glad that I thought to ask you to share your story behind that. I think that's really important. And I think that it is a great example of a coin trademark. And like I said, coin trademarks are great in terms of legal protection. It's easier to get them registered. They are a little more challenging sometimes in terms of marketing because you do have to educate the consumer a bit more aggressively about what that underlying product is. Arbitrary marks are also strong marks. They're words that are like actually real words, but they're not really related to the underlying product. An example would be BlackBerry for or is BlackBerry even around? I don't know, for handheld devices. And Julep Maven is also a subscription box, and it's a nail polish and beauty subscription box. And I think it's a great trademark. It's adorable. It's two fun words, Julep Maven. Um, they're real words, but they're not related to the underlying product. As with the coined marks, you still kind of run into the problem of it being a little more difficult to educate the consumer about what that underlying product is. Now, the really our sweet spot in terms of trademark protection when it comes from a legal standpoint and when it comes from a marketing standpoint are suggestive trademarks. And these are words and images that allude to the goods or services but don't actually describe them. So, a couple of examples I have here would be pepperoni for dog treats and BarkBox for the canine subscription box company. Those are two really good suggested trademarks. And, when you're starting your subscription box business, I strongly suggest that you pick a trademark that's somewhere on that scale of suggestive and up. So suggestive, arbitrary, or coined. If you go for a descriptive trademark, you're going to run into some problems potentially in terms of getting the mark registered at the USPTO. And the reason is the federal government is not going to help you enforce a trademark that they believe anyone should be able to use to describe their product. So there are ways around this. And I've given the example of honey baked ham. I don't know how many of you all are familiar. I'm always wondering if this is more of a regional company, but Honey Baked Ham Company is a company that sells honey baked ham. So you would think, well, how in the heck did they get their mark actually registered? But what happened was Honey Baked Ham Company was the exclusive user of the mark for over 5 years, and they used it continuously. And so what happened was they eventually developed acquired distinctiveness in that trademark. So if you do end up picking a descriptive mark, or you've already been using a descriptive mark for a while, don't fret too much about it. I still suggest in most instances to try to get it registered if you can. There are ways to argue around descriptiveness rejections at the USPTO. Another example I gave here, of course, is gentleman's box. That's a box that I found that is a box for gentlemen. So that's a mark that is, I didn't see it. I don't think that they've applied for it, and it's a mark that's going to probably run into some problems during the application process. If they've shown that they've used the mark over 5 years and can show the USPTO that that mark has acquired distinctiveness over that period of time of use, then they can probably eventually get it registered. I do mention the word generic here. You basically don't want to pick a mark that is just too generic for your subscription box business. I mean, obviously, you would want to avoid a mark like super cool subscription box because it doesn't tell anyone about what it is, and it would be very, very difficult to get it registered.
What another example of a generic maybe trademark would just be like the term subscription box. Like you probably couldn't go and trademark that because it's a very just plain phrase used in the industry.
Exactly. And if you happen, and as kind of an example, I'm going to go in a little bit on that. If you file a trademark application for Julep Maven subscription box,
Mm-hmm.
the USPTO asks you to disclaim the element subscription box. And really, at the end of the day, you don't want to include overly descriptive or generic terms in your trademark application. They don't add anything to the overall mark.
Mm,
Does
okay.
that help? I hope that helps.
It does. It does.
So another thing that you need to do, once you've picked a trademark and you think that, it kind of is somewhere on the spectrum of distinctiveness, it's at least suggestive, you're going to want to do a likelihood of confusion analysis. Now, this is something that you can do on your own, and I've listed 3 resources here. Namecheck and Noam are really fun resources to use to see if your mark could already be used out there as domain names, somewhere in the common law, and even as social media handles. Because when it comes to branding your subscription box, it's really important to try to get consistent social media handles if you can. If you're in love with a name, don't freak out if you can't get a particular handle. There's ways to get those at some point, but that's something I think that is important is to try to be consistent as possible when you're using a subscription box name on Twitter and Pinterest and Instagram and all the social media platforms. So whenever you're doing your own searching, there are quite a few inherent limitations. One of them is your time, and it's important to search different variations and spellings of your mark. So, for example, if I were doing a trademark search for Jesse for the mark Prosperly, I would say, hey, we need to search Prosperly and maybe Erlie. So think about that, that different iterations and spelling variations should really be done for trademarks. If you're gonna take that step and really search to see, just to make sure that no other entity is using that trademark. There are third-party search platforms that can help you do that, and I didn't list one here, but I do use a company a lot called CompuMark, and that's CompuMark.com, and that's a really good company to use to outsource any type of searching. Typically, if you're going to spend the money on outsourcing a search like that, you'll probably want to have a trademark attorney to go through the results with you and analyze the results. If you've been using a trademark for at least 6 months, and you haven't filed yet, I usually suggest going ahead and filing it, without spending all the money on the search. Now, if you're a brand new subscription box business, and you're getting ready to, work on your branding, and you know how important branding is for subscription boxes, I do suggest, at that point, to take that extra step and to do the preliminary searching that you can do on your own, as well as a comprehensive search through CompuMark. Okay, next slide, Jesse. Okay, so let's talk about protecting trademarks. So in the US, under our common law, the right to a trademark is established when a company adopts a particular mark and actually uses it in commerce. So in the US, we recognize what are called common law trademark rights. So let's say that you started using a trademark on January 1st of 2016. But let's say that you didn't file an application for registration until October of 2016. Well, the good news is that once that trademark registers in the US, your rights are going to actually revert to the January 1st date of first use. So that's the really cool thing. Now, keep in mind, federal registration does have significant advantages, and the major one is that you are granted presumptive rights to that mark throughout the entire United States. And I do have an unless here, and that is if there is a common law use prior to your use. However, that common law use could be limited only to a particular geographic scope of use. So that can get a little bit complex. So I'm not going to go into a ton of detail, but I think what I really want you to just take home here is that if you haven't filed a trademark application yet, don't fret about it a whole lot, and just know that once you do, and once you do get it registered, you're going to have a very strong intellectual property asset, and that asset rights will have reverted to the date that you first started using the trademark. Um, let's see. I saw a question here. I'm going to answer this. What is the difference between an R and a TM? This is a very, very popular question. The TM is for any mark that you're claiming as your trademark. And you don't even have to have a registration for it. Or, I'm sorry, you don't have to have an application for it. So if you're using your mark on your website or on your subscription boxes that are actually going out, you might want to put the little TM next to your trademark until you get it registered. And that is what the R in the circle is for. The R in the circle is reserved for federally registered trademarks. And these are called the notice symbols, trademark notice symbols. And you might want to use a little TM throughout, next to your trademark on your website, like I said, on your subscription boxes. And in the US, you can actually end up building up trademark rights and then losing those trademark rights. So if you go through a period of at least 2 years of not using using your trademark, let's say that you abandon your subscription box business, you can lose the rights to that mark through abandonment. You can also lose your rights through improper licensing procedures. So if you think at some point you might want to license your trademark, make sure you get an attorney to review any kind of licensing agreement and to make sure that you really understand the terms of that licensing agreement and what your obligations are and responsibilities and risks are as the trademark owner. And then also, another way that we lose trademark rights here in the US is failing to enforce your rights. You have an obligation as a trademark owner to enforce your rights, because this kind of goes back to what I mentioned earlier, that part of the reason trademark law exists in this country is to protect consumers. Okay, let's go to the next slide, Jesse. So, um, you have to, you have an obligation to enforce your trademark. But this is good because not only do you protect consumers this way, but it helps you build value in your company. And in order to enforce your trademarks, you're going to have to constantly monitor or police your trademark. You need to know what else is out there. If there could be any infringing conduct that's going on, you're going to need to know about it. So there's a couple of ways to do this. Um, One is to, put this in your calendar to do a Google search every month. And you can also set up Google alerts to help you. You could also use the resources that are in, I guess, a couple of slides ago, the NOAM and the name check resources to continuously check. You can also outsource to a third party. And CompuMark is one that you can outsource to. And this is the company that I mentioned a minute ago that will do the searching for you. They will also do policing and monitoring. And I totally forgot that I'd actually put their domain in here, but this is who they are. This is Thompson CompuMark. And for about $300 a year, which I think is totally worth it, they will monitor and police your trademark for you. Now that price can go up quite a bit depending on how extensive the search parameters are, but you can get into a pretty solid search for about $300. So if you have a subscription box business and you have a trademark that that you consider valuable, then I think it would be really smart to set it up to set up a search or I'm sorry, monitoring service with a company like CompuMark. I also mentioned here that you need to be ready, willing, and able to enforce your trademark. So when I say that, you need to have the gumption to want to protect that brand, and you might also need to have the funds to monitor and to potentially have to pay an attorney to send a cease and desist letter. And I'm mentioning cease and desist letters right here, and to be really careful if you do send a cease and desist letter. There are a lot of things that you can get hung up on. You can do it yourself. There are benefits to having an attorney do it. One is they tend to have more teeth. Number two, an attorney will help you draft it in such a way that you can't end up losing your rights in the long run. And I've seen people do this. They'll also help you make sure that you are indeed the first user of the trademark. You don't want to send a cease and desist letter without making sure that you're the first user of the trademark. And there's ways of sort of investigating this. And a trademark attorney will have the resources to do that. If One big thing I want you to be really careful about too is not being overly aggressive or mean in a trademark application, um, because recipients of trademark applications these days will throw them up on social media, and the backlash can be really, really bad if you're not careful. So I always really advise people to set the tone that you want to in a cease and desist letter, and only be aggressive if you absolutely have to. So you do want to be aggressive when it comes to protecting your trademark rights, but you do have to walk a thin line here. So Jesse's got me moving on to to copyrights. I know we're probably getting. I probably went a little longer than I meant to on trademarks, but I can't help it. That's what I really
Just
love.
just a little
And
bit.
I'm gonna.
It's all right.
No, you're fine. You're fine. And then there was a question here from Vladlina, and I'm so sorry if I messed up your name. But I'm going to talk about this. What she has asked, what are the copyright rules with pictures from the internet? For example, can I use photos from the same online store? I'm going to go into that a little bit when I talk about fair use of copyrighted works. So hopefully that'll help answer that question. But with respect to copyrights, so federal copyright law, U.S. law, allows the protection of original works of authorship fixed in any tangible medium of expression, um, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated either directly or with the aid of a machine or device. So what's really, really cool about this is when they were drafting the regulations for copyright law, they knew that technology would change over time. So it's like they worked this into this federal law, and I think that's kind of cool. But anyway, I guess that's kind of the IP geek in me. But copyright law itself, what is a copyright? It's a form of protection provided to the authors of original works of authorship, and this would include literary, dramatic, musical, artistic, and certain other intellectual works. So the Copyright Act generally gives the owner of copyright the exclusive right to reproduce copyrighted works, to prepare derivative works, to distribute copies and phonorecords of the copyrighted works, to perform the copyrighted work publicly, or to display the copyrighted work publicly. And the copyright lasts typically the life of the author plus 50 to 100 years, depending on the type of the underlying work. So let me just jump back to trademarks and how long a trademark lasts. A trademark will last as long as you're using it. There is, I think it's Stella Artois, the beer, has been in use since 1366. So trademark rights can last indefinitely as long as you're using the mark. So just some examples of the types of copyrights that your subscription box company could own. You could own the design in your logo, the design on your box, the copy and the look and feel of your website, any insert cards that you include with your boxes, including the photography and the language written thereon, and of course the images of your boxes that you have on your website. I do have a little tip here. If you outsource your creative work, get the copyright assigned to you. Copyright assignments can be super, super simple, but it's always good to just cross your T's and dot your I's. Let's see. Let's go to the next slide, Jesse. Protection of copyright. So a work doesn't need to be federally registered in order to be protected under federal copyright law. So the moment a person creates a work, that person is automatically and immediately vested with a federal statutory copyright protecting that work. However, there are benefits to getting a federal copyright registration, and one of those benefits is that you can enforce your copyright. If you want to learn more about copyrights and how to file for one, they're super cheap. And it's good just to have it on record. If you have a series of photographs of your subscription box, you could file them all together under one copyright filing, and I think it's about $45. I mentioned here some limitations on copyrights. One of the limitations is that a copyright protects only against actual copying, so it doesn't protect against the extremely rare possibility that someone may independently create a work identical to the copyrighted work. So just kind of keep that in mind. And then also another limitation of copyright law is the fair use doctrine. And this provides that the fair use of a copyrighted work will exist for purposes such as criticism, comment, news reporting, teaching, scholarship, or research, and these would not be considered copyright infringements. And I'm going to go into a little analysis that I hope that you can use to kind of help you get an idea of whether or not you can, your use would be considered fair use. Thanks, Jesse. You read my mind. Pain. This is a mnemonic device I think is really helpful to analyze fair use. You look at your purpose, your amount, your nature, and effect. So, what is the purpose? You'll want to ask yourself, what is the purpose of your use of that underlying work? Are you using it for something that's educational and personal, or are you going to be using it for something that's commercial or for profit? If it's educational or personal, more than likely it's just going to be considered fair use. Um, However, if you're using it for commercial reasons or for profit, you're going to want to start thinking, maybe this isn't really fair use. So remember, this is all sort of a sliding scale. You'll want to ask yourself, what is the amount of the work that I'm using? What is the amount of that underlying work that I'm kind of copying? The more that you copy, the less likely it's going to be considered fair use. As an example, if you copy 5 pages directly from a 10-page story, that wouldn't be considered fair use. Keep that in mind. Now, the nature, what is the nature of the work used? Is that underlying work factual, or is it creative? Is it a creative underlying work? The more factual that underlying material, the more likely that it's going to be considered fair use. However, the more creative it is, you may need to use less of it because it's not going to qualify as fair use. And finally, what is the effect on the market for this use? Does this use substitute for what someone else could have purchased? So in other words, does your use of that underlying work, does it discourage other people for some reason from purchasing an underlying copy? Um, so just keep these in mind when it comes to fair use. It's typically not a yes or no answer. And finally, don't be susceptible to the assumption that attribution is good enough. A lot of people think, well, oh, if we just say thanks to photographer so and so for this is his photograph. That's not sufficient. You can still be held liable for copyright infringement, even if you do attribute the underlying work. You need to get permission from the copyright owner if you're going to be using it. Next slide. Copyright enforcement. So because registering a copyright with the Library of Congress isn't necessarily a prerequisite to obtaining a copyright, I do like to look at that federal registration process of a copyright as your way of enforcing it. So there are certain procedural benefits that you're going to obtain if you do register your copyright with the Library of Congress. So keep that in mind. So let's end with trade secrets. Next slide, Jesse. I hope I haven't put you to sleep. So almost all businesses do have trade secrets that they don't even really realize that they have. Generally, any confidential business information that provides that business with some type of competitive advantage that may be considered a trade secret. So a trade secret generally has some cost associated with its development. And it's something that's not commonly known in that particular industry. So there really are no formal steps to protect a trade secret, but what you must do is take internal steps within your company to make sure that certain measures are being taken to protect things as trade secrets. For example, you might want to mark certain documents as confidential. You might want to keep certain documents in locked files, only share certain documents on a need-to-know basis with certain people. Even utilize a safety deposit box at a bank. That's a good way to protect something as a trade secret. Because if you do end up going to litigation with a former employee who has stolen your trade secrets, you're going to want to show that you took proactive measures to protect something as a trade secret. I'm just giving that as an example. Some examples for trade secrets This could be your customer list, your prospective customer list, your email list. If you have any particular techniques that you have for maybe packing your subscription boxes, that's not something that you're going to want to share with people, right? So it gives you some type of competitive advantage. Supplier and wholesale lists. Okay, now think about this for a second. One big thing that we have to deal with as subscription box owners is sourcing, and that takes a lot of time. So what if you ultimately got it so streamlined where you just had the supplier and wholesale lists that you can just hit quickly. These lists could be considered trade secrets for your business. If you ever wanted to sell your company, your subscription box business, all of these trade secrets would be considered assets. So, of course, you need to be very careful about disclosing it before you sold your business. But just keep that in mind. These are things that add value. These add value to your overall business. And I do mention at the very bottom, recipes. This is a really good example of something that's subject to trade secret. This is something that we all kind of understand. This A recipe is not something you would want to file a patent for, because when you file a patent, you have to disclose it. I gave Jesse the example the other day, and I'm going to use another Kentucky example. Kentucky Fried Chicken. Their recipe of 11 herbs and spices is a highly protected trade secret that only a few people actually know. So, and as I understand it, that the actual recipe itself is kept, under lock and key. And I think that wraps up. I'm not sure if we have the assignment or the Q&A next, Jesse. I can't remember. I'll let you show me the next slide.
Looks like we've got the Shia LaBeouf slide.
Oh, we got Shia LaBeouf. That's right. Okay.
Okay, after this we got the assignment here.
Awesome. Do you want me to go through this?
Sure,
You want me to
sure.
give the assignment?
Yeah, if you want to take a break from talking, I can kind of walk through this here. So
Go for it.
for you who usually come to our webinars, you guys know that we always love to give you something to do afterwards. To kind of take all this information that you've digested today and then apply it to your business. So it's June 23rd. So next week, next Thursday, you should take some time and take what Suzanne has told us and identified some trademark assets of your subscription box business. So is it your name? Is it something else? Is it some unique, type of imagery you've used on your box or something like that? Um, uh, Identify those, determine where on that spectrum of distinctiveness that Suzanne explained, where it lies. So is it really distinctive? Is it coined, or is it very generic and kind of bad? Is your box called Box? Maybe that won't work. And then add the TM or the registered trademark where applicable. And so, you can go through your site, places where you have your name, or you have where you think that you have a trademark asset. Go ahead and drop whichever sign is applicable, whether it's the TM for the trademark or the R if you've actually registered it. And just go through your site and make sure that you've kind of starting to button up your operation to make sure that if you do have people looking at it, you start to kind of build in some of those protections for yourself and for your business. Anything you want to add to that, Suzanne?
No, but I guess, yeah. I am actually really, really glad that we gave that last one as the assignment, because there are several questions here about the significance of the TM and the R. And so I think it's definitely one of those little things that, people kind of wonder about, like, what is the TM, and when can I use the R in the circle? And let me just be clear that you don't even have to have a pending application to be able to use the TM.
Right.
So, yeah,
So drop that TM everywhere on your sites, and then once you've registered, then you can start to use the R. Is that correct?
that is correct. That is correct.
So if you're like me, I have a lot of notes and I'm very confused. So if you do need extra help, now's the time to ask some questions. But also, you can reach out to Susie at her law group if you want to get some help. If you feel like you've got a situation that you want to pursue, or you just want to make sure you want to walk through your business. She's a resource for you, and you can see her contact here. But let's jump in the Q&As. I'm going to leave up these action item reminders, and I will mention here too that she'll be added to our resources page on subscriptionschool.com. So if you are looking for this contact information down the road, on the resources section on Subscription School, you can find her there after today. So I'm going to leave up some of these action item reminders, and then we can start to walk through some of these questions. Um, this was a good question that I saw come up, and it was about domains. And so, does having the
Mhm.
domain help with trademarking?
Not at all.
Quick, that was a quick answer, but you should get it anyway.
Yeah, your domain name is not much more than just your address. Your address on the internet. You can't utilize your domain name as a specimen of use in your trademark application. So when you file a trademark application at the USPTO, you have to, at some point, either at the time of filing or during the application process later on down the road, you at some point you have to show the USPTO that you are using the trademark. One way that you can do that is you can show your trademark on your subscription boxes next to your products, and a little checkout icon that shows that you can purchase those subscription boxes. But the domain name itself, it doesn't really add a whole lot to it at all.
Got it. Got it. Okay. The next question here is, so is the TM mark necessary? So I think we kind of just talked about that, where you could add the TM even if you don't have a pending application. But the second part of that question from John, and it seems like a couple people asked this too. Does it cost money? What's kind of a ballpark of the cost for it? What does a normal application cost people usually? I guess without maybe a preparer helping you, like so without attorney fees included. Um,
Okay, sure. Yeah. Okay, so I see here he asks, is the TM mark necessary? Um, and I'm assuming that he means the use of that notice symbol.
mhm,
Um, it's not required by any means, but it is helpful because one thing that it does is it makes it clear that that is your trademark, and it puts third parties on notice that you are claiming that word or image or logo or whatever as your trademark.
right.
It does cost money to register a trademark. The USPTO filing fee is $275 if you file it online, and that is per class. Um, when you if you file the trademark application on an intent to use basis, and you basically tell the trademark office, we intend to use this mark, but we haven't started using the mark. At some point later on, you are going to have to show use of your mark, and at that point, you'll need to pay another $100 per class.
Got it.
There are also maintenance fees that go along with your registration, and those are incurred every 10 years. So I don't know what they are currently. I can't remember. It's been a while since I've I've had to file any maintenance fees.
So
But
it
it
sounds like
does change periodically.
as you go through the as a trademark process, expect a couple $100 excluding if you have an attorney help you to do it, which is a pretty cheap expense when you consider the protection you get for your name or your idea.
Yeah. Yeah, and a lot of times what people will do, it's totally understandable, is they'll go ahead and file a trademark application. And if for because honestly, it's not an entirely complex process at the outset, the filing itself, but there are sometimes problems that will be incurred during the application process, and then at that point they'll get an attorney to help them. Two of the biggest obstacles that people seem to have when they file a trademark application is either they didn't do a search before they filed, and there's a prior filed mark that's like theirs, and so there's a likelihood of confusion. There are ways to try to argue around that, and honestly, if you get a rejection like that, I strongly suggest you get a trademark attorney to do the response for you, because they know sort of the language and the additional factors that go into analyzing a likelihood of confusion rejection. So at that point, you might want to get an attorney. Another big reason people get rejected is that they pick a trademark that's too far down on the spectrum of distinctiveness.
Right.
They pick a trademark that's descriptive. Yeah, usually people don't have a problem with generic, but they file descriptive trademarks, and the USPTO will reject it, and they'll say that your mark is merely descriptive. So we aren't going to give you a registration, because why should we help you enforce a trademark for something that everyone should be able to use to describe their product.
Got it.
Um, yeah, so those are the two biggest rejections that you tend to get. Another obstacle that people occasionally get in the application process is after the examining attorney looks at the trademark and everything seems to be going smoothly, the next step is that it's published for opposition. And opposition is a 30-day period where third parties are given an opportunity to oppose registration of your trademark. And so they can oppose it based on confusion with their own marks. I've seen marks opposed because certain parties think that a mark is too descriptive. So if you get an opposition proceeding filed against you, you're gonna probably, if you really want the mark, if you want to proceed with it, you're probably gonna have to get an attorney to help you through that. That's a pretty complex process.
Always defer to your lawyers.
Yeah.
So what I want to do before we end this here, we'll probably go just 2 minutes over. I want to ask this question one more time. Based on the
Sure.
information we've covered, do you own intellectual
Yeah.
property? So I'll leave this up here for a couple seconds. And as we do that, I'm just going to address a couple of these other questions. It seems like we got a couple people asking again about photos. Um, and so, in terms of using photos you find online, like Suzanne said, I mean, if just attribution alone isn't going to protect you. If you should look at the usage rights, and when you do like a Google search for images, you can sort by usage rights. Look at what the image is classified as. There are certain free usage photo
Mhm.
kind of depositories like unsplash.com, or the free sources in Flickr, or those types of things. So if you're using lots of photos online, and you're wondering if, oh, can I use this photo or not, you should always look at the usage rights, which are usually attached to the photos. Um, you know, just using any photo you find online is not safe. One of the big people who pursue this, and
Yeah.
Suzanne, you might even know about this too, is Getty Images. They're very aggressive with protecting their images. I've actually
Yeah.
been sued by Getty twice before, so
See.
I mean, and that's I was much younger, and I was using it on a website, but
Sure.
they charge you like $800. It's like it's not a
Oh,
small amount. Um,
yeah.
and you should, when it comes to images, you should just get a deposit photos account and pay 15 cents
Yep.
per image, or use something that's classified as free to use. If you're
Yep.
not sure, I would say don't use it. So for all of you who are still asking about the photos, that would be my advice from being someone who's been served twice for that stuff.
That's great advice. That is great advice. Yeah, use a company like Deposit Photos. If you do find a photo you like for some reason, you do talk to the photographer. Make sure you get any type of license to use it in writing. A lot of times doing something like that's going to end up costing more than just finding something on a deposit photo site.
Right.
But yeah, you
Um,
have to be
so,
very careful.
so Tim asked, if I take a picture of a product that I might use in my box, do I have to get the okay for the company from that product? And this is a good question. Um,
Mhm.
and I would kind of, I don't know if my answer would differ from Susie's here. I always reach out to the companies that I'm going to be using in promotional materials or anything like that, to actually invite them to be inside of the box, and I show them the
Yep.
material in the first place. My assumption would be, if you're using someone else's very likely copyrighted or trademark visual assets in any way, you're exposing yourself to risk. Um, but I'm not sure if it depends on if you're marketing it. I don't know if you have any thoughts there, Susie. What if I want to take a picture of my box, and I put in I put in a ragu spaghetti sauce because I have a pasta subscription. Do I need to go to Ragu and ask if that's okay?
You are increasing your risks if you don't.
Right.
Now, I could give some business advice here, and you have to do what you think is best for your business. There, you're probably not going to get a cease and desist letter from Ragu if you do that,
Right.
and most of the time, if a company is approaching it from really a business minded standpoint and they're not getting stuck in the trees and forgetting to look at the entire forest, they'll let
Mhm.
it go because they know that really at the end of the day, it's not harming them. You know what I mean? It's good. They're getting exposure.
Right.
But you are increasing your risk if you don't request for permission.
I think a good
If
example. Oh, sorry to cut you off. You can go on.
no, you're fine. You're fine.
I think a good example for that, in that case, if you're using someone's product, is even look at the company and look at how aggressive they are with protecting that. Like for example, Nike. I think it'd be very risky to use a Nike symbol versus some, maybe more, um, uh, some lesser known or some smaller medium, maybe it's a medium sized company compared to someone who aggressively protects that trademark of theirs, and it's it's like a if you use like an Apple mark, for example, that is like an extremely well known trademark. I feel
Right.
like if you're kind of finding yourself in that situation, always on the side of caution. But like I said, maybe just look at the company and ask yourself, is this the type of company who would pursue it? I would assume that bigger companies who have really distinctive trademarks um, would be more likely to pursue it than not. Like if you run a jewelry business, definitely don't use that box and that color. You know, is do you really think that Tiffany and Co is going to come after you? Maybe not, but still, you're exposing yourself to that risk.
These companies are very aggressive in protecting their trademarks, and they spend a lot of money in not only registering them, but now at this point they've built so much value in them. They spend even more money in monitoring um, and enforcing their marks.
Right.
So yeah,
Okay, so let's see here. We got a couple. We're a couple minutes over, but I'll see if I can we can power through these questions here. Um,
sure.
okay, so
I'll see one from Sarah here. I'm from London. We got another Kentucky girl in the house. I
another
mean,
Kentucky bird. Nice, very nice. So then it says, what if you found another business with the same name as yours but sells different product and different services? Um, so maybe you have
well,
a box called, Prosperly, and also here in Portland, Oregon, there's also Prosperly Plumbers. Um, I
no, that's a great example. It depends uh, on a lot of things. You will know that you'll think about this that there are a lot of companies that do exist that have the same names, like Delta Airlines and Delta Faucets. So it is possible to coexist um, as a trademark with, you know, identical marks that are out there if the underlying goods or services are different. Um, but there are a lot of factors that need to be considered. One of them would be the fame of the mark of the other mark. So you know, I bet Disney doesn't have a subscription box company, but if you try to file a trademark application or have a subscription box company called the Disney box,
right.
and it didn't even have Disney stuff in it, it was something different. You're gonna get a big fat cease and desist letter from Disney company.
And Janet, like you
So
mentioned, if the other company you see isn't using the TM symbol or a registered, they probably didn't do the registration. I feel like a lot of small businesses probably don't go through these steps,
yeah.
especially if it's of a different vertical and has nothing to do with what you're doing with your subscription box. I don't think you really need to pay too much mind unless you really do feel like it's somehow infringing on your intellectual property. Um, if it's just another small business, I don't think it'd be worth your time or even expense in incurring legal fees to go after someone who might be doing something completely different.
Yeah, if you see someone else out there that is using a mark that is similar to yours, I mean, you're going to want to take several things into consideration. And of course, one of the big things is, what is it they're offering? Like I have a subscription box business, and let's say someone else starts up a plumbing business, and it's the same name. Really, what you need to consider is there a likelihood of confusion amongst consumers?
Right.
Now, we don't have a very high standard here, okay? We're talking fourth grade, right? Okay, a fourth grade consumer, you know what I mean? We're not saying, okay, highly educated consumers. We're talking about your average person. Would they get confused with my subscription box, for selling this product versus this subscription box or this plumbing company that started that's exactly the same?
Hmm.
If there's no likelihood of confusion, then there's no problem. Now, if you come into a situation where you've had actual confusion, obviously, you know, you're gonna probably want to think about sending them a cease and desist letter.
Hmm. Right.
But
So
I do recommend in these situations to to really analyze if there is a risk of confusion. To really think about that, really make sure that you are the first user of the trademark before you send a cease and desist letter.
Hmm.
I'm gonna keep pounding that in, but it's really important to do that.
So we got two questions here. So Patricia mentioned she's still a little bit confused on how on the distinctiveness scale for your handmade business. So Patricia, I would just suggest um, sitting back and thinking about some of these things that we have spelled out actually on the slide that we're looking at right now. So the words, the sounds, the colors, the shapes. If your subscription box, for example, has a custom inner box, and this is something that we trademarked at Conscious Box in my previous businesses, the inner box had like a diamond shape cut in the top of the box that we had a very specific logo around, and it let you peer into the box and see the next month's theme card. So it was like a very
Very
you know,
cool.
it was very distinctive, and it was a shape and some colors. So Patricia, maybe just sit down, look at your business, and ask yourself what you think is most distinct. And looking at the scale here, if you think it's a color or if you think it's a name, kind of plot some of those things out. And if you do have more questions about that, feel free to join us in our Facebook group and kind of pose those in there, and we can give you some feedback there. Tim asked. And this will be our last question that I see here that we haven't answered yet. What about international? So if I'm shipping to international places, do I need to go protect my IP overseas?
Maybe because Tim, it's a really great question. Federal trademark rights, which is what we've been talking about, rights here in the U.S., when you file with the USPTO, those rights that you're granted are only extended within the U.S. So you won't be protected in Europe. If you're sending your product through, somewhere in Europe and someone says, well, that looks really cool, I'm going to go file a trademark for that. I'm going to start my own subscription box business by the exact same name here in France. Well, in France, they don't recognize the same things that we do. They don't honor common law rights. It's essentially a race to the trademark office. You can file international trademark applications. In fact, there is a European filing where you can get protection in the entire EU. So that's really a really helpful way of getting some protection internationally. But you also need to think, would I actually be able to enforce this trademark
Right.
internationally? Because it would be very expensive.
And
Another hang up, oh, sorry, go ahead.
no, 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 you go ahead.
Oh, I was gonna say another hang up that we sometimes get with filing internationally is that whereas in the US, a descriptive mark is risky. I've told people like you can file it and you can maybe get it registered. You might have to argue around it or show that you've used it continuously for 5 years and you've developed acquired distinctiveness. Well, in other countries, they don't look they will not register a descriptive mark. They're a lot more rigid about that.
So honey
And
baked
like I
ham is
said,
being used all over Europe.
I'm sorry, what you said?
So honey baked ham is probably being used all over Europe.
Probably. Yeah. So, but yeah, it is jurisdictional. There are ways to get, your mark registered internationally.
And my
There's also,
my note on that
go
was
ahead.
going to be for you, Tom, or Tim. Uh, you know, with subscription boxes, they're just not very big overseas. The next two biggest countries that are interested in subscription boxes, the next three, I should say, outside of the United States, is Canada, UK, and Australia. So if you're really worried
Yeah.
about that, maybe, start in those places.
Yeah.
Because
Hmm.
outside of those places, the percentage of people who know about this idea, it's still a very new and kind of novel concept, is just very, very low. And so even if you did have some competitor that popped up in, you know, Russia or something like that, I don't know if it would be kind of like Susie was mentioning. I just don't know if it would be worth even pursuing or enforcing because of the consumer base in those countries are just so small compared to the United States.
Yeah, and when you're dealing with countries that aren't English speaking countries, you do need to look at translation issues as well,
Hmm.
and make sure that there's proper translation going on, and that your mark doesn't mean something weird or negative in a foreign country. So
Right.
there's a lot of considerations if you go internationally. That's a really
Awesome.
good question.
Well, great. We're about 15 minutes over. Thank you, Susie, for staying over with us. I know you've probably got a lot to do. Again, everybody, if you want to learn more about this, you can reach out to Susie. This webinar was recorded. We'll put it up on subscription here at school the next couple of days. The slides will also be available. And again, please come and engage with us on Facebook, in our subscription school group, on our Facebook page, on YouTube, and you'll be the first one to see the webinar recording, and you'll be the first one to be able to ask more questions. And so thank you guys again for attending, and thank you, Susie, again for doing this for us. It's a very dense topic, and I think you've been super helpful.
Well, I hope it's been helpful. Thank you so much for giving me an opportunity to share my knowledge with the subscription box crew.
Awesome. All right, everybody, you guys have a good rest of your day, and we'll see you all later.
Yeah, y'all have a good night.
Bye bye.
Bye.